May it please the Court, my Lord, I appear for the State in this matter together with my colleague Mr. Matenjwa. May it please the Court.
And may it please the Court, I appear for the first accused.
May it please your Lordship, I appear for the second accused together with Ms. Adhikari.
My Lord, may I go first and inform your Lordship of the current state of play in this matter. My Lord, the Court will be aware that this matter was postponed for two reasons at the last appearance on the 6th of April. The first reason was at the application of Mr. Zuma's team, and that was to bring a review application of the decision to prosecute him. My Lord, might I just mention that also on the 6th of April we were ready to go to trial, and we had a holding date of the 12th of November as a trial date. That situation pertains. The State is still ready to go to start the trial. That application to adjourn the trial on the 6th of April for review resulted in there being no application for review. The State has not received any application for any review, and no matter has been commenced. That being so, we are disappointed that that is the case. The application was granted on the basis that there would be a review application. There has been none. How we address that, I will inform your Lordship in due course. Secondly, the second reason for the application was for Thales to bring an application for representations, or to make representations to the DPP, to the prosecution. We had hoped that that application would have been brought within sufficient time for us as the State to have answered the representations by today. Unfortunately, the representations were only received finally the night before last, so effectively yesterday. So the State is not in a position properly to appraise the representations and to provide an answer to Thales relating to whether the matter, as they so wish, should be withdrawn against them or not. So in both respects, the defence have not come up to expectations. In respect of Thales, I must say my learned friends kept me informed relating to the representations and as to their progress. So I'm indebted to my learned friends that was in fact the case. But the fact is, the representations were received too late for us to give them an answer now. I might also inform the Court that in the interim, a further application was brought to the National Director on behalf of Mr. Zuma by way of representations to the National Director for a stay of these proceedings. As we understood it, Mr. Zuma requested us as the State and the National Director to remove this matter from the roll while issues of funding relating to Mr. Zuma were being sorted out. The National Director, it's a matter of record now, declined those representations. So the State declines to remove or to ask that this matter be removed from the roll, to be withdrawn or to be stayed, whatever the terminology is. So, my Lord, that is the situation as we sit here today. The State is ready, the defence is not ready. We have to deal with that. We, this morning, and we informed your Lordship of this in Chambers, reached an agreement between the State and the defence that this is how we're going to handle the matter as we proceed. And the arrangement is as follows. Firstly, we have agreed that this matter should be postponed provisionally to the 27th of July. That's slightly more than a month from now. In the interim, the purpose of the application is, at the request of the defence, firstly to get its house in order, and secondly, it is partially at the request of the State because we need time to answer the Thales representations. So that is the purpose of the application. In the interim, we have agreed that as soon as we are ready from the State side, we will inform Thales of the result of their representations, whether we will withdraw the matter or not. And if we decide not to withdraw the matter, then we have agreed that Thales have various applications which they wish to bring to the Court, and we've agreed that we will, before the next adjournment, have worked out a timetable between the parties, which obviously we would want the court to endorse, relating to when the various applications should be brought, when the state should reply, and when we will consider approaching the Judge President to give us a date in the appropriate court to resolve the application on behalf of Thales. So hopefully we can move things along and get the application going so that we can, in due course, reach a realistic trial date. As I said, the state is still ready on the 12th of November. Whether that date remains, given the application, will remain to be seen, but we're ready. As far as Mr. Zuma is concerned, Mr. Hully and I have discussed the funding issue. He said that he needs more time to further to make funding arrangements, and by the next holding date, he hopes to have an answer relating to his funding and to be able to be in a position to decide on representation for Mr. Zuma. That being so, Mr. Hully and I have also agreed that Mr. Hully, by that date, the next holding date, should be in a position to join and bring an application relating to whatever relief he seeks by way of staying the proceedings or other relief, whatever relief he wants. But that's so that those applications of both Mr. Zuma and Thales can be heard together. And that we will approach the JP in due course, hope sooner rather than later, with that program in mind. And the presiding judge at the next appearance will be informed of the progress of that whole procedure. And hopefully in that way we can move this matter to a trial date at a realistic date, which is what the state so eagerly wants, without any further delay. So, my Lord, if that suits your Lordship, and if the court is in agreement with those arrangements, then we would ask that the court adjourn this matter for those reasons to the 27th of July. Accused number 1 is on bail, accused number 2 is accompanied. So she as a representative, Ms. Guria, is on warning. So anything else going on? Okay. Nothing else? No. You're not on bail. Sorry, he's on summons, he's on warning. Yes, sorry, my learned friend quite correctly informs you Mr. Zuma is not on bail, he is on warning. He was summoned to this court. I do apologize for the mistake. Thank you,
yes, Mr. Hurley.
As the court please, the matter on the 6th of April and the representations and the submissions that were made then to court were to give the court the assurance that an application would be made by this date, in terms of which Mr. Zuma, that is accused number 1, would bring an application to review the decision of the National Director of Public Prosecutions. Those undertakings weren't likely made. They were made in the circumstances that Mr. Zuma's funding arrangement had been in place, as it had been in place since 2006. There have been various circumstances which have transpired in the intervening period, and I won't labor the court by actually taking them through all of those. But safe to say, it has caused us to reflect as to whether the arrangement with the state, by way of funding Mr. Zuma's representation, can be said to be firmly in place. It's those circumstances that cause us not to have brought the application by this court date. The other matter I think that bears mention, Lord, is the letter that had been addressed to the National Director of Public Prosecutions was not to ask that the matter be removed from the roll. It was purely to ask that these proceedings be stayed, pending there being clarity and final determination made by the state insofar as whether they are intent on funding the accused representation in this court or whether there's been a review of that decision. The Lord might well be aware that there's a pending application by the Democratic Alliance and another by the EFF, in terms of which they seek to set aside that funding arrangement. Those are the facts and circumstances that cause us, as it were, to be in default, and it's meant not to be, or not to demonstrate any disrespect to the court, but purely then to say in those circumstances, counsel's brief had to be withdrawn, and we find ourselves in this invidious position. As far as the date of the 27th of July, that is suitable, and if the court deems that to be a suitable date, then we are agreeable to that. And by that date, it will give us sufficient time to obtain clarity around the funding, so that we then would be able to, in consultation with my learned friend, map out a sort of timetable, as it were, which we would then be able to present to court.
Okay. What does does accused number one still wish to pursue the review application?
That is so, my lord.
Okay. All right. Is there another thing? Do you think that by the 27th we'll have covered all this?
My lord, it's hard to say. We are expectant of a reply from the presidency. We had addressed a letter to the Director General on the, sorry, if the court can just bear with me. We had addressed a letter to the Director General in the presidency on the 24th of May. As of now, we are not in receipt of a response, despite there being fervent attempts made to try and draw some response from them. So I can only say that I would deem it unreasonable if within the next week or two we weren't in receipt of a response, which will plainly set out what the actual presidency's attitude is. It might be mentioned that the President and the Minister of Justice have filed a notice to abide in respect to those two previous matters that I mentioned, and that of the DA and the EFF. So we really just want clarity about what does that impact, whether they are intent on maintaining the actual status quo, or whether there's been a revision of the agreement which accused number one has with the actual presidency.
Okay.
Thank you, my lord.
Yes, Mr. Kurtz.
Thank you, my lord. We confirm that which Mr. Downer has put on record is our understanding of the position, and the fact that the state need more time to consider Tully's representations is perfectly understandable in the circumstances, and we would agree that it would be fair to the state to ask that the matter be postponed to the 27th of July 2018 inter alia, for the purposes of the state considering Tully's representations and reverting back to us as to the result of those representations. Once that result of the representations are made known to us, we would be in a position to consider our position one way or the other, and we will endeavour to agree with the state on a timetable going forward consequent upon the result of those representations, as Mr. Downer has put on record. Just two issues that I just wish to add. The one is, as we understand it, the postponement to the 27th of July would be to the Pietermaritzburg seat of this court. As we understand it, the Durban building, the Durban High Court building is going to be under renovations. That being so, bearing in mind the Tully's representative in this court, Ms. Christine Gurria, as mentioned by Mr. Downer, she doesn't live in South Africa, and the next date would be a holding date, and we'd ask that the court specifically excuse her from attendance on the 27th of July 2018 in Pietermaritzburg, were the court to grant the postponement sought by all the parties. As it pleases the court.
Okay, thank you. By concern, this matter is adjourned to the 27th of July 2018 at Pietermaritzburg. The reason for that is that Pietermaritzburg has more accommodation and is very easy to manage a case of this nature. And secondly, at the request of accused number two's defense, she will be excused from attendance on the 27th. because that will be a holding date. There are still some applications to be launched, as Mr. Hali for the accused number one has indicated that accused number one still wishes to pursue the his review application, and there could also be some other application still waiting for the outcome of the matter, which is before court in Gauteng, in the application lodged by the DA and EFF. So at the moment, it's still early to say when the matter can be set down for trial. Mr. Downer, hopefully by the 27th of July, I think maybe some of the outstanding issues will be resolved, and the arrangement with the JP, as you have asked in chambers, whether there will be the same judge dealing with the matter. So far, I cannot be in a position to answer that question, but I hope by July 27th you'll know what will happen. Thank you. So the matter is adjourned to the 27th of July 2018. Accused number one, you want to attend court on that day until you are excused from further attendance.
That's confused.
And accused number two, you are excused from attending court on the 27th of July at the request of your counsel, but you will be later informed as to how the matter will further be conducted, whether your presence will still be required. It's not that we excuse indefinitely. You must not misunderstand that.
It's a pleasure.
Okay. Thank you. Is there any other thing?
That is all the business of today, my lord.
All right. Court adjourned.
Well done, Michael. Well done, brother on the side. He just accused number two. What are you talking about? I've been on your side many times. Sort of. Never been against. Hello, Annika Larson. No. You saw. There's a thing dropping out your side. I said, he said so.
Because we have to.